Hello and welcome to the AI regulation seminar with us today here in Mason, Hayes and Kern. Thank you to all of you joining us on both sides of the Atlantic. We're absolutely delighted to have you with us today. My name is Brian McElligott and I'm a partner in the intellectual property practice in Mason, Hayes and Kern, and I have a particular interest in all things artificial intelligence. I'm delighted to say I'm joined by two colleagues. I have Oisin Tobin, who's a highly regarded privacy and technology specialist and the current head of our San Francisco practice. We also have Michaela Herron, who is a highly regarded products lawyer with a particular speciality in digital health technology. In this session, we're going to be looking at how AI is currently regulated in the EU. We're going to look at proposals for new dedicated AI laws, which are published recently in a white paper from the EU Commission. And rather than dwell too much on the chapter and verse of any of that, what we're going to look at is the impact of the proposals by way of a worked example of something we're seeing in the market at the moment. This particular example is the use of AI in the context of recruitment screening. Please do feel free to send through your queries as we're going through the session, and we'll pick them up at the end. Now, why is this webinar important, or why should you sit up and take notice about what the EU is doing in this sector at the moment? First up, the EU sees AI as a strategic sector, a target for both funding and values-focused regulation, and that is definitely stricter than what you will see in the US, and many of you who are already dealing with GDPR understand this. There is an existing body of EU law that already regulates AI in the EU, and here we're thinking about things like GDPR and product regulation from both a safety and liability perspective. On top of that now, you have proposals for new rules under the white paper. In general, the EU rules will apply to AI products and services supplied to the EU, regardless of the establishment of the producer or the supplier. Our own view at the moment, from having reviewed the white paper and aspects of the liability paper, is that this could be particularly onerous for software providers, and it certainly will impact product design. Finally, and if you need another reason, is that this cannot be ignored, is that even after Brexit, the EU consumer population will be 450 million people approximately, and something not to be sniffed at. So before jumping into the legal aspects themselves, I thought it would be interesting to give you a little bit of background to the EU AI project and how it came about and the context within the world AI market. The EU has stated in the white paper that it absolutely sees the US and China as competitors for the world market of AI products and services. China is quite different from a regulation and, I suppose, investment perspective when it comes to the EU. What is permissible use of AI technology in China is certainly not something, I suppose, that would ever be considered, or many applications anyway, that would never be considered in the EU. And what I'm thinking about here, an example would be something like consumer social credit scoring. The US falls somewhere in between. My understanding, at least anyway, is that at the moment there is very light touch regulation of this area. And while there are proposals doing the rounds in federal papers, as far as I understand anyway, those proposals don't contain any concrete plans for the regulation of AI in the near term in the US. The story in the EU is quite different. The EU, via a high-level expert group, has been working on plans to regulate AI for the last couple of years. This began by pulling together that group to come up with a concept for both the investment and regulation of AI, and this concept is something called trustworthy AI. The EU has its plans to produce and regulate AI, I suppose, that will be the envy of the world when it comes to uptake, because it will be seen as, you know, a guarantee of trustworthy AI. So if you like, it's a kind of a branding initiative as well as a regulation initiative within the EU along its own principles. This is seen most starkly in a white paper that was produced recently by the Commission in February of this year. The white paper itself is like a tool or a mechanism for producing a roadmap towards legislation. So next step is anticipated, I suppose, to be legislation. And in this white paper, we have proposals for what new laws might look like. Overall, the thrust of the white paper is that there are areas in EU regulation that currently look after large strands of AI technology. Again, we'll be looking at things like GDPR and product liability and safety regulations. But there is issues identified with enforcing some of those regulations in the context of AI. And an example given there is in relation to things like the black box effect. Also, there are areas of this new technology which the EU feels and identifies in the white paper that are not yet regulated and need to be regulated. So then, what is it that this regulation will look like? Well, the key point to get into our heads is that what will be regulated is something called high-risk AI. And this breaks down into two items. The first of these is that the target will be, first of all, for sectors. Specific exhaustive list of sectors will be identified to regulate. At the moment, that list looks like healthcare, transport, energy, and the public sector. On top of that, only those high-risk uses of AI in those sectors will be those ones that will be regulated. And here, obvious examples are things like medical devices, maybe the ability to withhold or grant social security, and one in particular is surveillance. Now, notwithstanding that, you will also have on top of that an overarching principle of anything that is identified as high-risk AI will be caught by this also. And I think everybody will agree up front that the first thing is that we need to understand in great detail what high risk is, and we do not really have any information on that just yet. I think at that point it's actually a good idea to hand over to my colleague Michaela, who's going to introduce some of these concepts from a safety and liability perspective.
Thanks, Brian. Good morning and good evening, everyone who's on the line. The European Commission released a report which sort of should be read in conjunction with the white paper. And in that report, it contains a list and a really good analysis of some of the product safety and product liability considerations that we see arising through the use of AI. I have distilled these down to sort of 8 key issues on this slide, and I'm going to pick 4 of them to go through in a bit more detail and to give some sort of worked examples of how these challenges arise in practice. So the first sort of issue is autonomy, and obviously autonomy is one of the main advantages of AI and its ability to behave independently. The European Commission is concerned that AI-enabled products have the potential to change during the lifetime of their use in a way that isn't always foreseeable by the original manufacturer. And what that means is that traditional pre-market or pre-launch risk assessments or safety testing doesn't necessarily meet the requirements or make them fit for purpose once the technology is on the market. And that's because the behavior of the AI as it develops is unpredictable sometimes, and sometimes new risks are occurring throughout the life cycle of the product. So one of the potential solutions here being considered is the introduction of additional risk assessments, which could be required throughout the lifetime of the product, particularly when the product is going to be subject to important changes or updates throughout its life cycle. Another issue which is under consideration for this aspect is whether EU legislation needs to specifically provide for human oversight, and whether this should be inbuilt into product safety legislation. Data dependency is another key issue. Obviously, the quality of the data input dictates the quality of the data output. So if you're putting junk into your algorithm, you're getting junk out. And this is especially important in terms of developing your algorithm to begin with. So say, for example, we're seeing a lot of AI dermatology apps on the market at the moment. You take a photo of your mole with your phone, you upload it to the dermatology app, an algorithm is overlaid across the image, it reviews the photos and ultimately makes a determination as to whether or not you're likely to have a melanoma. So what's really important here, obviously there's a lot of safety issues around a software medical device like this, but what's really important is the appropriate quality of the image. So ensuring that the algorithm is capable of checking those data input specifications to make sure that the quality of the image is appropriate for use. Because if you don't have those protective mechanisms in place, then you risk having an algorithm which might misread the image and ultimately misdiagnose the characteristics of the mole, which can obviously have an impact on patient safety and patient care. One of the potential solutions that are being discussed in relation to this issue is having specific requirements that are introduced from the design stage. So there could be mechanisms put in place to ensure that the quality of data is maintained throughout the use of the AI-enabled products and services. So in other words, the app would be developed with very specific data input specs from day one, and it would be trained to and be taught how to reject bad data or reject images in this case that weren't meeting the appropriate quality or thresholds. Certainly in the medical device sphere, data input specifications are heavily scrutinized during the CE mark conformity procedure, and notified bodies in particular will really be looking at data input and how you are sort of controlling the quality of the data going in. They'll look at that in an awful lot of granular detail, so it's something to be extremely aware of. Software is obviously an essential component of AI-based systems. There's a big issue around software at the moment at an EU level, and the big question is whether the General Product Safety Directive and the Product Liability Directive actually apply to standalone software, so for example to apps. The Commission has recommended that there should be some clarity around the scope of these directives, so that there is clarity for manufacturers in relation to whether they apply or not. But secondly, the challenge with software and software updates is that software and obviously software updates can impact on the functionality of a product, and they can also impact therefore on product safety. And as a result, the risks associated with a product can change throughout the lifetime of that product. So one of the potential solutions being identified by the European Commission is to include specific requirements for standardization around this issue. And then finally, opacity. There is a real risk with self-learning features of AI-enabled products and services that it can result in this black box effect. And what that means is essentially degrees of opacity whereby people can't actually trace or understand what's happened in the event of a product defect or a safety incident arising. It can also be extremely difficult to try and understand who's ultimately at fault. Was it the software or was it the human who is supposed to have oversight? And this is a really sort of hot topic that we work with clients a lot on in terms of the medical device space. So when you're seeing AI products being used in hospital and clinical care settings, you have that intersection between technology and clinician. And if we take an example to sort of just think about this more in practical terms, if we think of software that's used to read x-rays or scans, obviously we're seeing quite a lot of software medical devices being developed at the moment who do these functions. And historically, x-rays would have been read by consultant radiologists, but now we're seeing software being developed which will actually review the x-ray film through the use of an algorithm and ultimately spit out a report which the clinician will then rely on. But if I'm in the hospital bed and I've injured my leg and I'm waiting for an x-ray report back on whether I have a break or not, the question arises as to whether should I as the patient be told that a machine is actually conducting that analysis? Because in my mind, I'm probably thinking, well, a clinician, as consultant radiologist is probably doing that. So there's an issue here around transparency, firstly. There's another issue then, which is the level of human oversight. So what happens if the software makes an incorrect diagnosis and says there's no break when there is a break? And for example, say the clinician, it should be blindly obvious to the clinician that my leg is broken, and he fails to intervene and notice that the software has gotten it wrong. There's a real question as to apportionment of liability there. And as a patient, it's going to be very difficult to try and determine, well, who should I be suing? Should I be suing the software developer, or should I be suing the hospital? Should I be suing the clinician? So you can see that the black box effect creates an awful lot of darkness for you as the ultimate user or beneficiary of AI technology in the health space. And it can make it really difficult for you to understand what was the defect, how did it occur, and who ultimately is responsible. So that's a really sort of brief overview of some of these key safety issues that we're seeing in practice, and which we all need to be thinking about while we're developing AI products. To try and put this into even further context for you, we have taken an example. It's actually a risk that's specifically called out in the white paper, and it's a good example to work through a lot of the GDPR and privacy issues that arise with AI technology, which Oisin is going to talk to us about. So the example that we've chosen, this is a recruitment app. It ingests CVs and has the capability to screen candidates. And there's quite a lot of technology that it might seek to use, but for the purposes of this example, we're choosing computer vision, so facial recognition. Secondly, natural language processing, so text classification, sentiment recognition of CVs. And then finally, speech recognition in screening interviews. So if we start by discussing how this app uses data, I think everyone will be familiar that with the dawn of the GDPR, data is extremely heavily regulated in Europe. So Oisin, what do the designers need to keep in mind from a data perspective here?
Thanks, Michaela, and hi, everyone. So from kind of GDPR versus new AI regulation standpoint, I think it's useful to kind of draw a distinction in your mind between two different sets of activities. You've got, on the one hand, the processing of personal data, which is effectively taking information about living people and doing something with that information. So in the context of this AI recruitment app, the inputting of CVs, how people perform in interviews, maybe even candidate speech, all of that sort of stuff falls under the ambit of the existing law, under the GDPR. Now, what's interesting with the new rules, if they are in fact introduced or developed, is that we are now looking not just at the processing of the personal data, but we are also looking at the raw material that goes in to train the AI algorithm in the first place. So Brian's going to talk about that a little bit more in a second, but in terms of kind of, your key GDPR considerations, there's as any of you know, who had to deal with the kind of European GDPR issue, there's a lot of different principles that would come up in a case like this, but there's a couple of big ones I just want to flag that you'd have to think about. First up, you need what's called a legal basis to process personal data. There's a couple of different legal bases you can use. Classically, the common one was the consent of the individual. Nowadays, people tend to process data based on the existence of a contract that provides or requires such processing. And then you could also maybe process data in some circumstances if it's in your legitimate interest to do so. So first thing that you need to think about is, do you have a legal basis to use this AI app in the first place, or to more accurately, to use data that goes into the AI app? This kind of brings us on to the second kind of overarching consideration that pops up a lot in EU privacy law, which is this whole idea of proportionality. And this is something that I think a business that was trying to roll out an AI app like this would have to think through very carefully. You kind of have to show that if you're processing data, you actually need to engage in that processing. And the more invasive the processing gets, the more difficult it may be. So something like facial recognition on an app like this, or something like speech, kind of speech analysis, might be seen as being very invasive, and you need to justify that very clearly by reference to a clear business justification or clear business reason. This leads on very nicely to the third thing we'd have to think about, which is privacy by design. And this is a concept that was adopted in the GDPR a couple of years ago. And it basically says that when you build a product, you have to build it from the ground up to ensure that it complies with European privacy standards. So when this product is being developed, the builders of the products, the developers, really have to consider the GDPR principles while they're coding the thing, as opposed to simply when it goes to market launch. So that's kind of a change from the historic practice we had under the old Data Protection Directive, and it's something that's really going to bite when it comes to the development of AI. Another point you'd want to consider on something like this is the EU's specific rules around certain types of personal data processing. So there's a lot of kind of types of processing that trigger unique requirements. Kind of two that are particularly relevant here. One is the whole area of facial recognition, very controversial in Europe. Generally speaking, leaving aside pretty extreme circumstances, you can't do it without someone's explicit consent, and it's very hard to get that consent. So on a product like this, if you're doing facial recognition, you may need to consider whether you're going to commission it or commission it, or in fact decommission it before the product's launched in Europe. And then another related point, which I'm going to come back to later, is the fact there's specific rules around automated decision-making around personal data. The kind of the short takeaway is that under the existing rules, if you're going to make a decision that significantly affects someone based on their personal data, additional requirements are triggered, and I'll come back to those in a bit. And then I suppose the final thing that kind of immediately jumps out when you look at something like this from a GDPR perspective is the whole requirement to ensure that personal data is processed fairly. Now, this is a super, super vague requirement, and it seems to, what fair processing means seems to vary, based on it kind of varies in the eye of the beholder. But in something like this, and there are some recitals to the GDPR that are very pertinent here, it seems to me that you can't have discrimination. So even under the existing law, if you were to have an AI app that was to engage in impermissible discrimination, not only would it cause problems potentially under employment equality law, but you could potentially have a violation of the GDPR as well. So all of this on the GDPR side goes to how you use data that's inputted into the app. But there's a new set of requirements that may be in the pipeline, which I'll let Brian speak to.
Thanks, Oisin. Yeah, these new requirements then are 6 requirements which are listed in the white paper, and the first of which is data. And it goes broader than personal data in that, you need to design your app so that the results of the app won't discriminate essentially, or won't give rise to illegal discrimination by reference to EU law. It just so happens that in our example here regarding the screening app, the vast majority of the data is going to be personal data. But there's so many applications of AI that aren't massively dependent on personal data. They use different sort of data inputs, and this applies to them as well. So I suppose suffice that they hit that high risk threshold. So it would be, if it's to come through, it would be a new obligation to design the app so that the test and training sets you're using, you put some thought into them so that when they actually trained the engine itself, it wouldn't give rise to discrimination, or if you saw it did, you adjusted your strategy. And that's, I suppose, a big change from the perspective of what's happening right now. Many people, because it's in their best interests and their commercial best interests to do this, because you want to have the best product possible. Now you're going to have this, or you may have this obligation to meet, where you're going to need to be able to demonstrate that you set out from day one, like Oisin said, and you designed your app specifically with this requirement in mind, and you selected your category of data to meet this requirement. So if you like, it's a design constraint coming in very early in your process.
Thanks, Brian. Yeah, I think it's really important for software developers to just really take note of that point in particular, that this all has to be really baked in from a very early point in your development process. It can't be an afterthought. It's going to be way too late, if you're getting to sort of pre-launch phases, looking back and wondering, oh no, should we have done something different? So be mindful of this from the start. It's sort of a crucial issue. There's a very heavy focus also on documenting compliance under the new regime. And Oisin, would those obligations apply to something like simple software that we have here?
Okay. GDPR record keeping is one of my absolute bugbearers. There is, I would say, quite a cultural distinction between the two parts of the world where I spend my time, which is Silicon Valley and Europe. In Silicon Valley, there is an attitude that you build stuff, you ship it, then you iterate on it, and it gets better over time based on feedback. The culture that we kind of see in European law, at least, if not business practice, is all about record keeping and showing that you are in fact complying. And frankly, there is a clash between these two worldviews that is really coming to the fore when it looks like software implementations around artificial intelligence. So under the existing GDPR, in this particular scenario, the company that is actually using the recruitment tool would probably have documentary requirements. The documentary requirements fall on the entity called the controller, which is effectively the body that's deciding how this thing is going to process data, which is probably going to be the company that's making the hiring decisions. So that entity is going to have a number of documentary requirements they'll have to comply with under GDPR. A lot of these come from what's called the accountability principle. This is a really nice sounding term. I call it the presumption of guilt, because it's effectively this idea under the GDPR that not only do you have to comply with the law, but you also have to show that you have complied with the law. So both to comply with this principle generally, and then also to comply with some quite granular documentary requirements that are in the GDPR, you're going to have to produce a lot of records if you're going to do something like this. So big ones would be what's called the records of processing activities, which is essentially a spreadsheet explaining how you're using data here. You would probably need to document any business interests that you are relying on to base your processing or to justify your processing. And then with something like this, you're probably also going to need a thing called a data protection impact assessment, which is effectively a risk assessment. So what this document does effectively is it explains how the data is being processed and what risks that gives rise to, what controls are in place, and then you assess the risk after the controls are applied. Now, all of that's going to apply even though it's a pure software play here. And I suppose the one thing I would say from practice, and what I see a lot of companies struggle with is just developing a lot of this paperwork is very time consuming, and a lot of companies, particularly smaller companies, actually struggle with this. And I saw actually was a news report earlier today, which was kind of a leaked summary of a European Commission paper on the GDPR 2 years in, where they even noted that there's a lot of friction being generated by GDPR. And I think this is a really good example of that, where it's a lot of producing paperwork more than anything else. Now, the white paper, however, kind of it takes a slightly different approach. It still insists on the production of records, but those records are focused, I think, more on the developer than on the company operating the AI. And I'll let Brian speak to that.
Yeah, exactly. I suppose what you're getting at is you're retaining records to an extent to prove what you did in your design is actually what you did. So in the case here of our recruitment app, let's just say you used a whole bunch of, say, like 1 million CVs to train the algorithm in the first place. You would need to possibly retain all those. It's not certain whether you need to retain all those, but you would need to retain certainly the reasoning behind your selecting, let's say, a category of CVs or multiple categories of CVs, why you use those, maybe if you iterated, why you dropped certain amounts of them and why you changed your strategy. All those records would need to be retained in order to prove that, you know, you didn't select data in the first place that would ultimately discriminate. I suppose this gives rise to some concerns, which I'm sure will ultimately be addressed in the legislation, but it's that, you know, you need to balance obligations with regard to retaining and disclosing and handing over information about your algorithms and what data you selected with your intellectual property rights, because, you know, as we're seeing with a lot of our clients at the moment, that the key IP right that is often used and enforced in the area of AI and machine learning is trade secrets, really, and not necessarily anything else, because of all the data involved and the processes and procedures involved. And you do not want to be maybe handing that over or disclosing it without good reason. And I suppose you can expect, like with GDPR, that there will be some element of pushback or some element of a saver with regard to how that's treated, this information, how it's treated and disclosed in due course.
I think the issue of record keeping is really, it's obviously in the medical devices industry, it's a really, really hot topic. And I think the medical devices industry actually might have a bit of a head start here in terms of already having plenty of obligations like this in place, you know, as part of developing the product and ultimately the tech file which gets assessed. And in terms of validation and verification testing, clinical studies, etc., there's already a sort of a very clear obligation in place in terms of what needs to be documented before you get your product to market. So it's possible that there are lessons to be learned from the medical device industry here in terms of the approach to other areas. So our next point is in relation to transparency, which is obviously a key issue. And we've talked about the EU's focus on disclosure around AI, but Oisín, would you explain to us how this would work here?
Sure. So transparency requirements under the existing law are probably, well, to a certain extent, aren't going to come as a surprise to anyone. You need a privacy policy with those delightful documents. So in this particular scenario, the company doing the recruiting would have to explain to candidates how their personal data is being processed. Strictly speaking, every company should be doing this already, but at least in Europe. But here they'd have to specifically disclose the use of the AI and the purposes for which the AI is processing the personal data. Now, that's sort of the general requirement. There's also a more specific requirement, which tends not to come up a huge amount of practice, but I think is going to be more relevant as AI takes a bigger role. And this is the whole idea of automated decision making. Now, under the GDPR, if you have an automated decision, which is a decision without human involvement, that causes legal effects or significantly affects a person, certain rights and obligations are triggered. One of those, which is kind of quite pertinent here, is there is an obligation to, quote, disclose the logic of the decision-making that led to that decision. Now, a lot of companies tend not to actually make these disclosures in practice, and that's usually because a view is taken that even if there's an AI or similar function in play, it's doing such a limited role that the AI is not making a decision which significantly affects people. So that's been that's the status quo at the moment. But if you were to have a broader role for artificial intelligence such that it is now making decisions that actually affect people, significantly affect people, then this obligation to disclose the logic of the decision making is going to be triggered. Now, this in turn immediately gives rise to two issues that at this point are a little up in the air. There's no clear market practice on them. The first one is around trade secrets. Because there is, as Brian mentioned, so there is in fact a carve out even under the GDPR that allows you to withhold certain information where necessary to protect your IP. So it's going to be really interesting to see the extent to which companies try to rely on that to actually not disclose the logic of their decision making. The second point, which I think is going to play out in the coming months and coming years, is, and this kind of goes back to a situation where the draftsmen with respect do not really understand the technology. And you have a question as to what it actually means to disclose the logic of a decision making if you are dealing with something that has been trained by machine learning. What I mean by that is a lot of these systems don't actually have algorithms in the way that someone sits down with a whiteboard, figures out some problems, comes up with a series of steps and encodes it. A lot of these things are just triggered or just programmed rather by by giving them a problem and throwing tons of data at the problem. And so it's actually can be very difficult to figure out why certain decisions are actually being made. And I think there's going to be a really interesting thing in terms when we have this sort of idea of explainability and we have decisions being made and we actually can't explain how the AI reached that decision. That inability to explain a decision could actually cause problems under the existing law. Now, if we move over to the white paper, again, we see additional transparency requirements here. They have a slightly different slant because what we're really looking at more is clarity around the fact that someone is in fact dealing with an AI, and this seems to be designed to deal with a future where people don't know if they're talking to a human or they're talking to a machine. And I'll hand it over to someone who I'm quite sure is a human, which is Brian.
We'll see. Definitely, it is something that I think comes up an awful lot in the press as well. Is that people, and this actually came out in the white paper, is that this lack of trust of take up of AI because of some fear of loss of autonomy. So then there's this sense that we want to know what it is exactly what we are dealing with. And we want to know in advance, and we want to know in an objective, concise, and easily understandable manner. And that is what is point number 3 under the requirements listed in the white paper. I suppose in the context of our recruitment app, I mean, at the moment, I expect that if there was some form of a chatbot asking you a few preliminary kind of, silo type queries to get you through the first gate, it would be absolutely obvious to you that you were dealing with a chatbot, and there may be no reason to be, even speaking about that. More, it goes back to the point about at the initial sign-up phase to maybe applying for a particular role, that there will be some sort of a notice that says, throughout this process, some form of a machine will be used in the background to screen your application and will make decisions with regard to your progressing from stage to stage. And that is the piece I think that the white paper is getting at, and as one of the examples it gives around transparency. From the perspective of the product owner and designer, they need then to understand or figure out how am I going to communicate this in advance in an objective, concise and easily understandable manner. I mean, I have to think that when it comes to things like unsupervised learning, that, you know, there's going to have to be a kind of middle ground reached, where you're not going to be able to explain everything, but it's more very high level information will be given with regard to what it does and what are the consequences of what it can do for you, you know, you not being progressed to a following round. But on the whole, again, if you kind of get into the mind of the product designer and the product owner here, it's a disclosure requirement and at the outset, a process constraint.
Yeah, I think that's a really interesting point, because actually in the report from the European Commission that accompanies the white paper, one of the issues that is flagged is whether there is a sort of an increased risk of distress or excessive stress for people who are involved with AI technology in lieu of humans normally doing the job. And I think with the recruitment app we have here, it's kind of an interesting question as to whether you as the applicant would have any sort of emotional or sort of psychological reaction to the fact that a machine is actually sorting through your data in order to progress you through a job application process. And, or, you know, does that cause you any sort of increased distress or stress? And if so, how does the developer of the app take that into account, and what appropriate warnings need to be placed on the product as a result? And that sort of brings us on to the next point, which is around robustness and accuracy. Now, the example I gave earlier about our X-ray software, obviously in medical device territory, we are heavily regulated in terms of accuracy and proving our claims. But for an app like this, I mean, there is a question of, well, what happens if the app gets it wrong? And is there an obligation that the AI does a good job? Could somebody suffer some harm as a result of being incorrectly or inappropriately being booted out of the recruitment process? I mean, Oisin, from a data perspective, obviously from a tort and personal injury or potential distress perspective, that's a separate question. But from a data perspective, do you think there's a legal obligation to ensure that AI is going to do a good job?
I'll give you the typical lawyer answer. It depends.
That's a cop-out.
Yeah, it's the cop-out. The GDPR and like existing European data protection law really wasn't devised with this situation in mind. So it focuses, fundamentally, it's a procedural type of law, by which I mean it looks at the steps that people have to follow when they are going to handle personal information. It doesn't really focus on issues of quality control, though there's kind of more of those trends developing over time. What the GDPR does say, and this is a long-standing principle of privacy law around the world, is you have to ensure data is accurate. So if the AI was to create inaccurate data, then that would trigger various obligations with the GDPR. It would create rights to have the data corrected. It would also potentially be a breach in its own right of a specific data protection principle. So if you can point to inaccurate data being created, I think you would potentially have a claim under existing data protection law. Similarly, if the AI worked in a way that was seen or engaged in processing that was seen as unfair, as I mentioned earlier, it's very vague, but effectively, I think any engaging in any sort of unlawful discrimination would likely be seen as a form of unfair processing. You would potentially be able to bring a claim under GDPR. But I have to say, you know, the law wasn't really designed for this, and I feel like you're kind of trying to fit kind of square pegs around holes here. And I think that leads into sort of one of the kind of gaps that's sort of seen in the legislation, and that's sort of where the white paper and the European Commission is kind of thinking as to how it can develop the approach here.
Exactly, yeah, and it is indeed identified as one of the key areas where there is a gap, and not just a need for a tweak, but a proper gap. What they're trying to achieve here is that the AI, again, will be trustworthy from the perspective of being consistent and not give rise to errors that will lead to, I suppose, harm to people. It's funny, what comes to mind is what happened in a Premier League football game last week, where a goalkeeper caught a football and carried it over the line of his goal. No goal was actually awarded because the goal line technology that was used did not indicate to the referee that a goal had been scored. And so the referee blindly relied on that. And I think it's something that people are concerned about. And it goes to the trustworthiness point that flows right through all of this, in that there's a concern about people relying too much on AI that has a level of autonomy, and that giving rise to risks. Also within this robustness and accuracy requirement, there is a requirement for the AI to be resilient against attacks and data manipulation. I mean, there are many examples in the last year or so about how data can be manipulated and give rise to very different results. One that comes to mind is how protesters in Hong Kong last year were able to apply makeup, just small amounts of makeup, in order to deceive surveillance technology so that they wouldn't be caught or identified on the streets. So it just goes to show that there are ways and means to trick or fool certain, and in many cases, very sophisticated AI applications. And this is what this particular requirement is looking to deal with.
So if we look then at sort of the last issue on this point, it's in relation to human intervention, which obviously Brian just mentioned, and the level of human oversight that's required. This is something that comes up obviously quite a lot, again, in the medical device industry, in terms of manufacturers being very, very clear in terms of what the role of a clinician is, for example, vis-a-vis the technology, because obviously there's an awful lot of risk related to that particular intersection between where does the machine finish and where does the clinician start. And I mean, when we're talking about an app like this in the recruitment, it's obviously, it is different. It's not as regulated as the medical device industry. But the same question arises really, to what extent can an AI application just essentially be, you know, press start, off you go, run on autopilot and just let it do its job without any sort of human oversight? I mean, Oisin, do you have a view on that?
Yeah, I mean, the first question you've got to ask is what sort of decisions are being taken by the AI? So your threshold question is whether or not the AI is engaging in any legal decision-making or decision-making with similarly significant effects. So if the AI is not making significant decisions, then as a matter of current law, no, there is no right for intervention, at least not under GDPR. If the AI is in fact making decisions that significantly affect someone or have legal effects, then certain provisions are triggered and there's a requirement for certain safeguards around those decisions. And that could include, in this particular case, the decision as to whether to grant or refuse employment. And I suppose the crucial point that's relevant is in this specific scenario, there would likely be what's called a right to human intervention, which effectively means that if someone thinks the AI has gotten it wrong, they have a right to complain to an actual person. Now, this obviously gives rise to all sorts of really interesting issues as to how you can scale a product if every time someone objects, it has to go back to someone's desk for manual review. And that person, I should stress, should actually have a right to genuinely reconsider what the AI did. So you have at the moment, under GDPR, some right to human intervention. But it tends to only be triggered in cases where the AI takes a decision which significantly affects people. And I should stress that what actually tends to happen a lot in practice is if you've got an actual serious decision, you normally insert a human in the chain of decision making, and then it's often structured such that the human and not the AI actually takes the decision, so these roles don't apply at all. But if you've got a pure AI decision that does significantly affect people, then yes, you have a right to appeal it to a human under the current law.
Great, thanks. And under the white paper, this consideration is just very specific in that in the design of the application you're using, they want there to be some sort of a human in the loop, and there are many different examples given in the white paper. So let's just say in the context of our recruitment app, you know, do you at the outset design your app so that there are certain gates past which the app won't make any decisions without a human intervening? Or do you just allow it to do its thing and have a check at the end where the human actually won't allow something to happen until it has reviewed the decision? So from the perspective of people designing these products, it's another design constraint that will have to be inputted early in the process. And it's something that gives rise to, I suppose, kind of thinking outside the legislation itself. How would this impact businesses? Well, a requirement like this, I think, would introduce a requirement internally in businesses for some degree high-level training of AI teams to ensure that they're aware of these sort of requirements and that they're in their heads when they're designing products. Now, finally, what we're going to look at here is enforcement. There's a proposal under the white paper for pre-market conformity assessments, which is quite a step change, really. So what it's basically saying that if you're producing these apps, even if they're just software, there is the possibility that you will need to conform to pre-market testing, or you'll need a stamp or an approval before your product will be released to the market. And that could include checking your algorithms and data sets by reference to the requirements. That's a big change. These will obviously, as we said at the top, apply regardless of your establishment. And overlaying all of this will be a new integrated national and EU governance structure to oversee compliance with conformity requirements. Now, I'm conscious of time and we want to get onto a few of your queries. I think those 2 points there in red and the key takeaways might be the most pertinent when it comes to what you need to be thinking about. If we take now maybe a look at some of your questions. I have one here, says, if these are only proposals, what are the chances we will see any new EU law on this? I think that we certainly will see some law on this. And the reasons I think this is that it's been in train for over 2 years now, and there's been a very defined scope of work, which is constantly being refined down to this particular process. So while we might not see all of these end up in legislation, we will see something happening here. Michaela, can I ask you one actually here on a medical device? There's one here that says that, have you a view on how the medical device regulation and the new regime proposed might or should relate to one another?
That's a very good question. The good news, obviously, for the MDR is that it hails from 2017. So unlike some of the existing other product safety legislation that's in place in the EU, it was designed during the digital era. So it's already quite further along compared to a lot of the other product safety frameworks that are in place in the EU. That said, it's definitely not perfect. And there are certainly, a lot of issues that we've spoken about today that would need to be more fine-tuned and probably through the use of guidance or standards addressed appropriately through the medical device industry. Obviously, it will be interesting. Obviously, the MDR has been pushed back now a year because of COVID. It'll be interesting to see how the marriage between the two frameworks actually plays out. A big question for me, really, in the whole thing is more around the patient-facing part of it. So, to what extent really do patients need to be told that medical devices are being used in their care to make decisions about their treatment? I think for me, the whole transparency piece, it's going to be really interesting to see how that's actually dealt with under new legislation if it comes in.
Okay, Ashleen, I see a couple of GDPR related queries. Do you want to pick up one of those?
Yeah, there's one here, which I'm just going to read out, basically asking that the EU authorities have been very slow to investigate privacy by design issues under the GDPR, and do we believe that authorities will be more alert in policing any law requiring non-discriminatory design for AI? It's a great question. So I think the premise of the question is correct. There has not been a huge amount of enforcement to date focused purely on privacy by design issues. What I have seen in practice so far is that privacy by design issues come up in regulatory enforcement action by European data protection authorities where there is some other problem. So they will find something else, like you didn't delete data you were supposed to delete, and then they will throw a privacy by design allegation or claim or charge into the mix as well. They'll say, like, you didn't delete the data you were supposed to delete, and the reason you didn't delete it is because you didn't have privacy by design systems in place. So while it is technically a freestanding principle, in my experience so far, it is a compounding variable. It tends to be thrown on an existing charge to kind of ratchet up the tension. In terms of this sort of AI point and the whole issue of discrimination, I think if you were to have a situation where the apps were acting in a way that was unlawful and was causing difficulties, then I think that what would probably gain regulatory attention in the first point would be the perceived harm the app was causing, such as facilitating discrimination. And then a privacy by design issue would probably come out in the context of any investigation into that matter. So I would agree that I think pure privacy by design investigations are rare enough, but what tends to trigger them is some sort of other harm or misconduct. And I think that if you were to have an AI facilitating discrimination, that's the kind of thing that seems to my mind to be very ripe for regulatory attention, because it's very new, very novel, and potentially you've got a real world harm the regulator will be trying to address.
I see one here that is kind of funnily aimed at me. It's an anonymous attendee who says, I read that in one case, CVs were sorted to exclude applicants that put 2 spaces after the full stop, it being thought that only applicants above a certain age would do so. I take it that this is where the laws are aimed at stopping. Well, I do double space after a full stop, and I have been given out on many occasions for doing it, so I guess that makes me old anyway. I suppose it is, and this really is kind of coming down to an employment law question really rather than anything else, in the sense that, you know, in some kind of cases, you will be entitled to discriminate on the basis of age for particular job categories. I would expect that, you know, you may be able to do that, but it is indeed, you know, the point of your question, it is indeed what they're getting at when it comes to the reason you choose to do certain things with your data sets and your training sets, and why you need to be very sure why you selected those decisions and ensure that that won't get you into hot water if you're ever pulled up to justify them.
We might take one last question, and Oisin, I think you're up, and probably a number of people are wondering about this, but can we expect an update to the GDPR and foot of all of this?
Very hard to say. So getting privacy legislation through Brussels at the moment is a challenging endeavor. It's probably the best way I can put it. So for example, we are still looking at you know, an update to the e-privacy regulation, which is the rule that, I mean, it governs a lot of things around telco privacy, but most of you will know it well as the cookies rules and the spam rules. So the existing e-privacy directive is the reason why you get an irritating banner every time you go to a website. And there has been debate for years about updating that. Originally, the plan was the updates would come out at the same time as the GDPR back in 2018, and it's still going around in circles. Heaven knows when the legislation will be adopted. So I think that sort of, you know, you've got kind of already a lot of focus on trying to get existing laws passed, which are not going anywhere quickly. The GDPR itself is also an incredibly difficult piece of legislation to get over the line. And I think there is a feeling that it is already pretty robust. So my sense of it is that we probably won't see any changes to the GDPR, but what we may see is additional supplementary rules that may be adopted in certain cases. You know, based on kind of the white paper, based on, you know, record keeping, that kind of thing. Maybe tweaks to the automated decision making rules. They apply in a slightly broader way. So you might have some tweaks like that, but I do not think you're going to see an overhaul of the core legislation here. It would just politically be too difficult to do it.
Okay, thanks. I think given the time, it's probably a good place there to wrap up. Those of you who have a few questions still with us, we will come back to you. Anybody else who has further queries, please don't hesitate to email any of us, as you see our details up there. Thank you all for giving your time today. We're absolutely delighted to have done this session with you. We're going to be sending out a survey after this session, and we would like to hear from you about further topics you would like to hear from us about. Thank you very much.
Thank you. Bye.
Bye-bye.